there's no way to deal with it. So there's a lot of things you can do from a practical standpoint and from a legal standpoint in order to help the family avoid that as much as possible. But before we go into too much detail, just a couple quick reminders that if you have questions that are coming up as we're going through this, you can send those into the Q&A function on Zoom, and we'll see that come up. And then just keep an eye out for an email at the end of this where you'll get a handout from us, which is just a little grid of possible reasons for conflict in the family, what tends to happen as an outcome, and what can be the preferred outcome when planning is actually done around those concerns. And you'll also get our feedback form where you can let us know that you'd like us to set up an initial consultation with you, with somebody in our office. And those are complimentary consultations. We do schedule them for about 2 hours, ask you to bring in a lot of information, but hopefully by the end of the 2 hours, we can give a pretty good recommendation based off of what your concerns are and what we'd recommend. So to get started, I think our biggest concern with families a lot of times when they come in is making sure that family harmony stays in place. After we're done talking about like the financial components of how do we plan for these types of assets, often is our concern is what do we do to make sure that the siblings still get along, or that we're not, I guess, putting pressure on those pressure points that would cause some concerns. And I think there are a couple big sides of this, of different components of this type of planning. There's conflict that can come up while you're still living. And then there's also conflict that can come up after you've passed too, after the estate is being administered, whether that's through probate or through a trust. So I think during lifetime, it's really important to, where possible, discuss your wishes with your family. And I think that can take the form of financial wishes, whether that's wishes regarding like certain types of assets, business assets, for example, or like family farms. That's really important to have those conversations during lifetime and not just do the planning and not actually talk to anybody about it. And there's also the side of health concerns and health wishes. There can be conflict sometimes amongst family members when people have maybe differing opinions on what like the end of life wishes should have looked like for mom or dad. So I think it's really important, where possible, to sit down and have those verbal discussions with people, as uncomfortable as they can be, because without having those discussions, everybody is just sort of taking at face value the documents you had and maybe interpreting them differently. It's much different when they can hear it from mom or dad directly.
Especially with healthcare. I mean, that agent is really supposed to be stepping into your shoes in general. So it's very important for whoever you name to know that. But in order to keep kind of conflict, because ultimately it's still just one person making that decision, even if your family is kind of coming from it as a team approach, it's important that they know, okay, I know mom or dad said this to me. I know this is what they want in kind of these circumstances. Think of things that you've seen personally in your life, different healthcare situations that you might be in. And it's good to just express those to your families. That way everyone feels that, nope, this is what they would have wanted. And we can be most at peace with that decision.
Yeah, you don't want to be, I think too often people with, especially like living wills where you spell out the end of life wishes for yourself, I think too often people think that this is going to be almost like a step-by-step guide of what that's going to look like in all situations. And that's actually one document where you don't want to be overly specific in terms of like timing requirements or what, I guess, absolute statements on any type of treatment, because you want flexibility for your healthcare power of attorney to be able to make those decisions. But that's where it's really important to sit down and talk to the people making that decision and say, I know I'm giving you some pretty broad authority with this, but here's what I'd like that to look like, or if this is the situation, then, maybe hold off making certain types of care decisions. It's going to look different for everybody, but having that conversation is really important, and having the verbal conversation is important, not just like through text or email. Sit down with the kids and talk about it. But with financial decisions, this can also be really important, because I think a lot of people try to plan equally for their kids, or they want things to be as equal as possible. And that can look really different depending on what they view being equal, like what that looks like to them. And also what types of assets that person holds. So especially when we're talking about certain types of assets, Fair and equal can be very different things. So it might be with like farm families in particular that one or more of the kids is more involved in that farm and has put more sweat equity into that farm over the years than the other kids have. So there are times where, as much as the family wants it to be equal, the planning ends up with maybe one of those kids who's worked on the farm potentially getting more in value than the other kids, but they've also put some more effort into that farm too. So dividing things equally can be an absolutely perfect goal. It can be perfectly fine to try to do that as much as possible. And these farm families, where possible, try to do that too. But if it's not possible, and there are more important factors in your planning, especially when it comes to particular assets, and if the division of those assets would actually cause potential issues or conflict, you need to look at, well, what's more important in this situation? Is it the survival of this asset, this family property? Or is it truly just everything being equal? So there's not a one size fits all with dividing things equally.
Yeah, you want to think about what your goals for a particular property are too. So the farms that Justin is talking about, sometimes the important thing is that, someone is going to maintain this. Someone is going to take care of the farm and be in charge of the farm when we pass. And the same thing can often apply to like family cabins. What you don't want is a cabin where no one can really agree on how do we pay taxes, how do we maintain it. So then ultimately that thing that you really wanted to kind of create a legacy for future generations is lost because people can't agree on some of those things. So if you want to give a particular item to someone outright and you're trying to balance it, you can always do that. But I think a general point too is you can't always get everything exactly equal. So the importance of having that conversation, say, okay, this is what I have. This is my plan. I'm doing this because I have these goals or have these specific things that I want to do. And then that can give your kids more of a sense of, okay, they really thought about it. It's not equal, but it's also not, no one's being treated too unfairly in that situation. And hearing it from you is going to be very different from if, the sibling who is receiving more being in charge of that and then having no idea that that was how it was going to be distributed can cause some conflict there. So being clear about what you want, why you want it that way, and having those conversations ahead of time can help kind of ease the conflict after you've passed.
And especially with like real property, real estate, where that's being the biggest concern and whether or not that's divided equally. This is often the hardest thing to decide on, because dividing it equally could result in somebody wanting to sell a portion of their share, whereas everyone else wants to hold off on it and keep the property. So you have to have the discussion of what would my kids' goals be with this property if it were to go to them too. So whether that's a family business or a family farm or a cabin, if one of the three kids, for example, just absolutely is going to want to sell, but there's not enough assets to equalize things out with them, but it's important to keep that property in the family, you need to do planning and have discussions around, is it really that important to you to be a part of this property if you're just going to want out? And talk to them about the obligations that come with that property, especially like a business like a farm where there's a lot of debt associated with this business at times. You might have to take on certain liabilities, or there's risk involved, inherent risk with owning this from a financial standpoint. And there's a lot of work that goes into continuing to own it. So I think too often without these discussions, the beneficiaries just see it as a kind of, this is the dollar sign amount of what that's worth to me, without considering all of the other things that are involved with it. So equal can be perfectly fine in certain circumstances, but it can also mean that you're putting a certain property at risk, or you're creating pressure points where there didn't need to be any, because people just never had the conversation of what does it look like if I actually own this property.
I'm thinking of personal property as that, dollar signs, or if you have someone who really cares about the value of the item that you're receiving. Also, you have, your home or your cabin, or your business, other properties that you'd have. You also have the assets within those properties. And oftentimes when it comes down to dividing up personal property, you can have someone who has more sentimental attachment to a particular item. It's not the value of that item. It's this memory. It's this, connection that I have between myself and this person. And really that item is just, a memory. And then you can also sometimes have someone who is more particular on, okay, you value that item sentimentally, but it would receive this much. So I want to have my fair share of, the dollar amount, the liquidity of those items. So one of the important things to think of when it comes to personal property is if you had known of any, if someone had expressed to you, like, I would want this item, or especially so if multiple people have expressed to you that they would want this item, or you worry about how they're actually going to divide up their property. If you have someone who's a little bit more on that, dollar signs values versus someone who looks at property a little bit differently, you can lay out in a will or a trust how you'd want personal items to be divided. Either leave a good degree of, flexibility, allowing whoever you have to be in charge. But you can also set aside items off the top. So, specific items of jewelry or collections, or, anything that would have family heirlooms, both within your family, and then also if you had friends or family beyond that. But what's most important is that if you know an item is going to cause conflict, or if you just kind of wanted to be clear on, this has meaning to me, I want this to be handled in this way, there's a way with wills and with trust to kind of get that all outlined ahead of time. So that way it's less conflict at the point when they're trying to divide up personal property as well.
And sometimes too, when we're talking about dividing assets equally, it's not a conflict standpoint, but maybe you want flexibility around not dividing every little account or every single thing, equally, but you want the value to be spread out equally. And where that's possible, that's great, because it's still, they're getting equal value, but it maybe doesn't make sense for everybody to receive 1/3 of the share of the IRA or 1/3 of the share of the home, right? I mean, you can set this up so that your trustee, if you have a trust, or personal representative, if you're using a will, has a little bit of flexibility in making sure that they get their share, but maybe we have some tax planning options too. So sometimes that's maybe less likely to cause conflict, but I think if somebody finds out that, man, I had a much better tax situation if this had happened, and it wouldn't have harmed the other people to do it that way, they might be a little upset about that.
Yeah.
So, and it's not that people often do this intentionally, it's just that, they don't know that they have that flexibility. So if your documents that you're using provides for the authority of the trustee or the person in charge of the estate to make sure that they can allocate assets not pro rata, but just equal in value at the end, that they have some flexibility to do some really nice planning for each other. And so that, that's absolutely something that you can set up and talk with them about and say, look, I don't expect you to take 1/3 of this equally. I think kind of another really like kind of the last thing I guess we'll talk about in terms of the financial side of dividing things equally, that can be a huge problem, is when people, when it comes to bill paying. So very commonly, a big concern after someone passes away is that what it says in the document is not what ends up being the end result. And that's often because of how the bill paying occurred. So really one of two things I think happens. Usually one person is left more than other people because they're the one that the parents or the family members expected to pay the bills. So they're left more, like payable on death, transfer on death, just through beneficiary designations. Or they divide everything out equally by beneficiary designations, but then somebody has to still pay expenses, and maybe not everybody's sharing in those expenses equally. So with the first side of things, when it's going to one person or more is going to one person with the intent to pay bills, well, if it's payable on death or transfer on death and it's their money now, they don't have to use that money for that purpose. They don't have to redistribute that money after all's said and done. So your equal might not actually be equal at that point, because you left more to them with the intent that they would use it for bill paying, and then maybe they didn't, or maybe they didn't divide up what was left equally.
Or they couldn't.
Or they couldn't,
Yeah.
They're gonna, so there can be reasons that people can't make gifts, and that's what you'd be asking them to do if there's Medicaid concerns or like bankruptcy concerns. So what would be better in that situation is to use your will or use your trust as the source of those bill paying funds in authority, so that the personal representative in the will or the trustee of the trust, they have to use the money to pay bills first, and they don't have a choice to not spread it out the way you would have wanted them to. So that can cause a lot of conflict if the rest of the family finds out, oh, this person had more money than me and they didn't share it like they were supposed to, but legally speaking, that person didn't have to. And it can be a really common source of conflict. And then the reverse, of course, where it's all spread out equally, but then one person maybe paid more of the expenses. If they can't get reimbursed from that by the others, and again, those others beneficiaries don't have any obligation to do that, that can be another source of conflict, thinking that, well, this is unfair. I did the right thing and nobody shared anything with me. So bill paying is a really common point of concern for people in terms of, and I think a common oversight by people when they're talking about making sure things are fair and equal. They think, well, I divided it equally, or this is what would happen, or what my kid would do. But then it's not enforceable, right? You can't force it to be fully equal and all said and done if that's the way you do it. You have to use a will, or you have to use a trust as the source of that bill paying authority if you want that to, if you want to guarantee that that end result will be what you intended. So, this can be a really common concern with people, but another really common concern, I think, is what happens if there's somebody in the family that we already have conflict with, that we want to talk about leaving, maybe leaving less or leaving out of the plan entirely because of past conflict we've had or past relationship, strains that we've had within the family. How do you avoid this causing a problem down the road? What's very important to do if you truly want to leave somebody out of a plan is, if they would otherwise be entitled to something, you really need to specifically call out that you're disinheriting them, or that you are not including them on intentionally, that it wasn't a mistake. Because I think too often, especially if somebody's not really thinking about this and they're trying to do things, maybe not by using an attorney, they're just doing things by beneficiary designations, they may not leave it to that and not include that individual, but leave it to the others. And then that person who was left out thinks, well, that might've been a mistake, or I should be entitled to something. So when you have a will or you have a trust, you specifically call out that this was on purpose. You don't have to go into details of why, and often it's better that you don't, but you just say it was on purpose, that we're leaving this person out. It was intentional. And, for the purposes of this document, they'll be treated to have passed before me. That's the legal way that you say this person is not included. And there's 2 points of conflict with this. One, if you don't do that, they can obviously cause a problem by saying they should have been entitled to something. But there's also the other side of it, where the person who's left out, you can help avoid a lot of conflict by having lifetime discussions again with this. I always encourage clients, where possible, if they are leaving somebody out, to make it known to everybody, including that person potentially, that, hey, I am thinking about this. This is my intent. I'm not including this person, and I want it known. And you don't want to leave that to like the discovery of the family after you pass away, because that's where everybody is already upset. That's where emotions are running high. And if that person finds out at that time, they could cause some legal problems.
Yeah, and as someone who has nothing to lose is probably more likely to cause problems there too. So I completely agree that conversation ahead of time can help avoid a lot of conflict. There's also planning that you can set up within your estate plan to help manage conflict when you've passed. So one of the things that, we kind of say at all of our seminars and webinars is just a misunderstanding that, if you have a will, that means that you're not using the probate process. And so if you have a will, that means that your plan is really to have your estate go through probate. And probate, just a couple of points regarding, the conflict is, it's overseen by a judge. So if you ultimately feel like your family needs some level of judicial oversight, you're probably better just starting off by using the probate process, having them be in front of a judge. But one of the difficulties with probate too is the fact that, it's public knowledge who you left things to. And if you did disinherit someone under sometimes the notice requirements with probate, if they're considered to be an heir at law to you, they're also informed that this process is ongoing. They're kind of being told who the personal representative is, the fact that they've been disinherited. So the more information that someone has is potentially the more ammunition that person has to actually create problems. So just know, if you did a will, that's public information. It does have that judicial oversight. I'm not saying that if you had correctly, made sure that you clearly disinherited them, that they're going to be able to get that, corrected by a judge. But it's still the fact that they have more information than they otherwise would have if you had used like a trust as your estate planning tool. Because a trust is going to be more private information. You know, your trustee knows what's going on, the beneficiaries can receive information about what they receive. But you don't have that same potential judicial oversight, which sometimes I've seen that be more of value depending on the circumstances. So it's just a balance of information, who is going to cause problems, but ultimately, if you're wanting that, you know, privacy aspect of who you've disinherited and some of those things, you're more likely better off with a trust. A trust can also be unique in that you could look at having a no contest provision, which would say specifically, like, even if that person was receiving from you, or even if everything was equal, if someone was to try to cause problems, if they were, you know, threatening litigation, that the no contest provision would say that you would forfeit your share, which is a good scare tactic, not always kind of held up in court. But it is good to know that, like, you could have a no contest provision within your trust to kind of encourage that harmony, encourage staying out of the court system, and, you know, you still have that private administration. It's just that probate is a tool that you want to, you know, intentionally use, and either fully use, you know, a will or a trust, and then know the privacy or public nature of both of them and what's really going to be a good fit for you.
Yeah, and you can always put no contest clauses in really any documents you're using, and when what those effectively say is kind of like an actual disinheriting language is, yeah, if you do this or cause these problems, you're disinherited. You're treated to have died before me. And these can be very expansive. They can also be very limited. And like Abigail mentioned, depending on how expansive they are, certain judges have different opinions on these things. So, you know, if these end up in court, like through a will, you might have them be less enforceable if they are more restrictive in that document, just because you're really at the mercy of which judge's opinion you're following at that point. So with a trust, you tend to see more expansive no contest clauses that, like, hey, if you sue the trustee, or you try to file a claim against the estate, or you say that I didn't have capacity and you try to get more than you were entitled to otherwise, those can be a lot stronger because, like Abigail said, there's not the oversight of that judge throughout that whole process. It's a private administration. It doesn't mean it ultimately wouldn't end up in front of a judge. I mean, I suppose if somebody was really determined, they could find a way to you know, get something in court, but it's at the very least very dissuasive. Where this can be really helpful for you too is, you know, when somebody's truly disinherited, there's less to lose, right? You have nothing to lose. What are you losing other than attorney's fees at that point? Where it can be really persuasive to that person is if they are being left something, but potentially it is not an equal amount. You know, so for all of the reasons we mentioned earlier, it might not be a truly equal inheritance just in terms of value. If that person tries to contest that in any way and that becomes enforceable, they could lose what they actually are getting. So you tend to see this be a lot more helpful in situations where it isn't just an equal division, or somebody is causing problems because they find out that they're getting less than everyone else. And again, using a trust for this is going to keep that information a little more private than if it were going through probate with a will. Because of the ability for somebody to find out what's actually in the will, because it's a court process, versus with a trust, if the language is drafted properly, you can say, hey, you're only entitled to information on your share and nobody else's. And that can protect not only the overall estate's value from somebody trying to contest things, but also protect the other beneficiaries from the wrath of that one person, so to speak. So there's a lot you can do to avoid these conflicts. I mean, a lot of it involves conflict around things or assets that come up after somebody's passed away. So discussions are always, like family discussions are always really important in the planning process, especially with family property, things that have been in the family for a long time, whether it's real estate or items, because those are the things where emotions are high, even when there's perfectly logical reasons that something might not be divided equally. So the discussion we often have with clients is there is, you know, hey, this would be truly equal if everything just divided by the percentages, but that doesn't mean it's what's fair to the people involved in that planning, or fair to you and your wishes. So keep all of that in mind when you're talking about conflicts around things or items in your estate, assets of the estate. But also with the healthcare decisions, make sure you have those discussions too, because nobody can read minds, and looking at a piece of paper that says, well, I wouldn't like to be kept on life support, can be a lot different than actually hearing it from you. So we did just get a question. So at the end of last week's seminar, we were talking about retirement accounts. We mentioned using pre-tax IRAs to pay for long-term care expenses. Can we explain more about this and recommend, is this recommended because long-term care expenses are tax deductible? So last week, one of the things we talked about, and I suppose this could also play into whether things are equal or not, depending on how you have things divided on that retirement account asset. With retirement accounts, with pre-tax retirement accounts, a lot of people try to, do tax planning around it during lifetime. Maybe they're looking at, converting some of that over to a post-tax Roth account, or, figuring out how to lessen the tax implications for the kids. The reason we recommend, where you already know you have to spend money on your care going into like a skilled nursing facility or assisted living facility, when you know that you're going to have to spend some money, it's better to use pre-tax money to do that, because after you exceed 7.5% of your adjusted gross income in your unreimbursed medical expenses, which care tends to do pretty quickly for people, it's fully tax deductible. So you can offset a lot of what you would have to pay in taxes on those accounts by deducting that at the end of the year. And in most cases, we often tell people, don't even withhold those taxes anymore. Don't have it withheld, because you just get a massive refund at the end of the year anyway. So yeah, using pre-tax retirement accounts is a great thing to spend on your care if you already have to spend money on your care. Now, if you don't have to spend money on your care and you're trying to protect it, maybe there's other things you can do, but at that point. But if you know that I'm going into assisted living and they're telling me I have to pay for 2 years before they'll even let me stay here on Medicaid, and if I have enough to do that in my pre-tax retirement account, that might be something like the first thing I'd look at to spend money on. So yeah, that's a great question. So I don't see any other questions right now, but just a couple quick recaps. Keep an eye out for the email from us where you'll see the feedback form where you can let us know if you'd like to reach out and set up an initial consultation. Again, those are complimentary, so you don't pay us anything to come in and talk to us initially. And you'll also see the chart of different types of conflicts that come up, or concerns that can cause conflicts, which we were kind of going through today too, but it's a good summary of that. And then next week, we're actually going to be, our topic will be on 6 things to avoid when caring for your parents. So we'll go through a couple different common mistakes or concerns that people have when they're starting to care for a loved one. So parents, could be any loved one. That can be there's a lot of things people do that cause problems when that person's about to go and care. We do have one other question. Can the IRA in one spouse's name be used for the other spouse's care? It could. You could use the other spouse's IRA for the other spouse's care, but when only one spouse in Wisconsin is receiving care and the other is still healthy or just not on Medicaid, their retirement accounts, so the healthy spouse's IRAs, 401ks, regardless of if it's pre or post-tax, are protected from the other spouse's care. So that would be one that you would probably not want to spend on care if you could avoid it, because it's safe money.
You still get the unreimbursed.
Yeah.
If you're filing jointly. But since it's a protected asset potentially for Medicaid, if that spouse who needs care has an IRA, I'd spend those funds first. So
what you could use for the unreimbursed medical expense deduction, if you are filing jointly, is you could certainly use that opportunity to do some Roth conversions relatively tax efficiently, but you wouldn't want to actually spend that money on the other spouse's care from the healthy spouse's retirement account, because it's just, at that point, the protection of it is outweighing any tax benefit you're getting by actually spending it. But Roth conversions could be a good opportunity there. So yeah, with that, I will, and I guess I should say, we'll let you go enjoy the rest of your day, and we will see you guys next week to talk about avoiding mistakes when caring for a loved one.